Roe is dead. The abortion debate rages on. What just happened, and what's going to happen to this country? That's next. Hey, welcome back to the Farah Show. The Supreme Court just overturned Roe and Casey. Abortion laws are kicked back to the states. Now what? I just saw in the Babylon Bee that Roe has been aborted in the 198th trimester. But all joking aside, regardless of your view on the morality of abortion, from a purely legal perspective, Roe and Casey were weak. And I'm just going to summarize some of those main arguments of the case and spend a few minutes on what's new about this opinion versus the leaked draft. In the final opinion, Justice Alito left the essence of the opinion the same as the one that was leaked about a month ago. He still argued that the Roe ruling did not come from a constitutionally relevant discussion, and many of the assertions were plainly incorrect. The 1973 decision cataloged a wealth of information that had no bearing on the meaning of the Constitution, and in fact, the opinion had a numbered set of rules that are more like what would be found in a statute enacted by legislature, Alito said. In other words, the SCOTUS went way beyond its role. The Constitution makes no reference to abortion, he says, and no such right is implicitly protected by any constitutional provision. Roe made this tortured attempt to define the time when a baby could survive outside the womb. It acknowledged that states have a legit interest in protecting a potential life, but the court just made arbitrary lines and didn't explain its basis for the trimester viability idea. Constitutional scholars who were pro-abortion admitted that the Roe opinion is not based on constitutional law. At the time, about a third of the states had allowed abortions, and 30 still prohibited abortion at all stages. Even liberal Justice Ruth Bader Ginsburg said that Roe interrupted the political process. It was the exercise of raw judicial power, according to Justice Byron White, who wrote the dissent back in 1973. Now, in 1992, the court revisited Roe, and it was in a case called Casey. This violated constitutional thought even more. It threw out the trimester scheme and said no state can impose a regulation that'll impose an undue burden on the woman's right to an abortion. No one really knew what undue burden meant. Since then, the debate has continued to rage. Neither ruling settled anything. The nation is strongly divided on the subject. We've got 50 states, and at this time, just one more than half, 26 states, already prohibit or will prohibit abortions at some level as soon as that ruling is official through the judgment process. Alito argues that regardless of whether the state makes abortion on demand a right or whether the state makes tight restrictions based on the unborn human being argument, that ordered liberty requires that elected representatives will need to decide the issue in each state. So at the end of the day, Roe and Casey failed to make the case that the Supreme Court should exert their authority to weigh the arguments and decide how abortion should be regulated in every state. As such, the Supreme Court of the United States, or SCOTUS, returns the argument to the people and their elected representatives. That argument is really all the same that it was when that draft was leaked. But Alito did add a few things. Number one, a fierce rebuttal of the court's liberal dissenters. And then, number two, a direct shot at Chief Justice John Roberts. First, let's look at Alito's potent arguments against the three liberal dissenting justices. He basically says that their arguments are legally frail. Now, when I read the dissent in light of Alito's rebuttal, the three liberal justices don't really seem to be making objective sense. They sound like upset high schoolers making emotional arguments with very little logic. Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan delivered a dissent that basically amounted to this. Roe's been in place for nearly 50 years, Casey for 30 years, and you shouldn't touch them, even if they weren't put together the right way. Alito starts out with a foundational flaw in their argument. The three dissenters failed to show that a constitutional right to abortion exists. They couldn't identify any pre-Roe authority that supports the right. They don't even try to lay a foundation for their case from the Constitution. Alito said, the dissent is very candid that it cannot show that a constitutional right to abortion has any foundation, let alone a deeply rooted one. The dissent does not identify any pre-Roe authority that supports such a right. No state constitutional provision or statute, no federal or state judicial precedent, not even a scholarly treatise. Abortion's simply not in the Constitution. Therefore, it must be left to the states to sort out. The primary argument from the three liberal justices is stare decisis. This is the concept of precedent. In Latin, it means that you will let stand a previous decision. Roe has been around for almost 5 decades, Casey for 30, so let the ruling stand. Alito's response is straightforward. There is a systematic legal standard to use to determine if stare decisis rules or if the ruling should be reexamined. If a case comes to the SCOTUS, they must follow that 5-step process in light of the Constitution. There are times when the Supreme Court gets it wrong and when they rule unconstitutionally. And it is and was correct for the Supreme Court of the United States to overrule a previous unconstitutional ruling. So Alito starts with the most venerated civil rights decision in American history. The SCOTUS had previously allowed racially segregated schools. Those were bad rulings. So in 1954, that same Supreme Court of the United States not the same one, but the Supreme Court of the United States overruled them. And when they did, they actually overruled 6 SCOTUS precedents. Their correct ruling reestablished equality before the law. Now, in order for the Supreme Court to correct itself, it had to stare decisis. And precedent is important, but it must be subordinated to correct constitutional thought. Alito went on to prove that adherence to precedent is not an inexorable command. In a less famous case, Alito shows how SCOTUS overruled itself in only 3 years. In 1940, the Supreme Court had made it a requirement for school kids to pledge allegiance to the flag. Certain religious groups objected. So in 1943, SCOTUS, the Supreme Court, ruled that the Constitution did not require public school students to salute or pledge allegiance to the flag. This overruled the 1940 SCOTUS. It's a big deal that just 3 years after the precedent, the Supreme Court overruled itself. And that's because in 1940, that Supreme Court was wrong, very wrong. We have religious freedom, period. So SCOTUS corrected the error. The dissent argues that Roe and Casey should never be overruled based on precedent. But when a case is egregiously wrong on the day it was handed down, it should be corrected. The court has overruled other cases. And abortion doesn't have some legal superpower to be exempt from proper constitutional application. Precedents should be respected, but there are numerous instances where the Supreme Court overruled itself. The kids with religious beliefs can't be forced to say something against those religious beliefs. The kids with certain skin color can't be prohibited from attending school. Racial segregation was wrong, so it was reversed, and it should have been. There are times when precedent is not a good determinant. When precedent is wrong, it must submit to the Constitution and be corrected. So Alito lists over a dozen instances where the Supreme Court overruled itself. And there's a reason for that. It's better to get it right than just leave bad law in place. The court's supposed to be the ultimate judge of whether our laws are constitutional. And the real goal is whether our constitutional freedoms are protected. That's their job. So when the law is unconstitutional, it should be overruled. The court does not have the authority to decree that an erroneous precedent is permanently exempt from being evaluated. Yet that's what the dissenters want. Roe is one of those unconstitutional laws. In order to reverse something, all 5 factors have to demonstrate that there's this constitutional violation, and those things have to be in place. And Roe checks off each box for whether a previous Supreme Court ruling should be overturned. It shouldn't be done lightly, but when precedent is wrong and when it's overwhelming, the Supreme Court has no choice but to get it right. You don't want to keep living under a bad law. Alarmingly, not once do any of the liberal justices even try to defend the right of the state to protect potential life? They talk about the burdens of motherhood and the difficulties faced by poor women, but never the right of the state to protect life. Alito put it this way: the dissenters have no regard for a state's interest in protecting prenatal life. The implication in their dissent is clear. The liberal justices believe the Constitution doesn't permit states to regard the destruction of a potential life as a matter of any significance. In fact, the dissent never allows for the concept of a potential life. The three liberal justices require us to believe that a fetus lacks even the most basic human right, the right to live. That is a scary idea. So Alito rightly states that nothing in the Constitution or in our nation's legal traditions authorizes the court to adopt that theory of life, or some would say that theory of death. The dissenting justices also made the case that there would be potential political fallout. Alito's argument's simple. All the corrections to the court, every one of them, all the ones in the past, had political fallout. The Democrats in the South who wanted to keep racial segregation in place were livid when they lost. They had demonstrations and stupid protests and all kinds of things with fire and white hats, but they were wrong. Those Democrats wanted to treat people unequally. The 1954 Supreme Court of the United States that overruled that racial segregation allowed for people to be treated equally. And that was a good overruling. The risk of political fallout's not a reason to abdicate jurisprudence. So Alito says, whatever influence the court may have on public attitudes, they should actually stem from the strength of our opinions, not an attempt to exert raw judicial power. So Alito says that the court should make laws objectively and should not exceed the scope of its authority. Pretty reasonable to me. It should not allow extraneous influences, such as concern about the public's reaction, impact the integrity of the court's work. Regardless of the political ramifications, the court does not have the authority to let that consideration influence their decision. When they accepted the job to be on the Supreme Court, the court accepted the job to interpret the law. And from that perspective, there is no honest legal dispute. The Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. Well, the dissenters said that states could use their power to impose criminal penalties on abortion providers or people seeking abortions. And they said, acting kind of like legislatures as opposed to justices on the Supreme Court, and they say that that would be disastrous. So Alito demonstrates that to be a lame argument. Of course, states can make the decision to protect innocent life, and of course they can determine how to protect that life. It isn't up to the court to introduce legislation. The three liberal justices didn't even try to defend the viability line, this other argument. This is the Roe concept. In Roe versus Wade, it concocted these elaborate rules for each trimester of pregnancy. Yet it didn't explain how there was any constitutional basis for coming up with that scheme. In fact, back in 1973, neither party arguing their case to the Supreme Court argued for the trimester framework. The court just made it up. Neither party argued that viability should mark the point when a state would be able to insert itself. The 1973 court just acted like a legislature without having the bother of worrying about being reelected. There was no history, no precedent, no cited source that supported their trimester policy. And that's why Justice White called the Roe decision an exercise in raw judicial power. Roe did not ground its decision in text, history, or precedent. It relied on an untrue historical narrative. It had no bearing on the Constitution. Now, how do we know it was untrue? Well, in a recent podcast I introduced Larry later to you, He was the PR guru and the author who worked so hard to get Roe to the Supreme Court. Amazingly, the Supreme Court of the United States relied on Larry Lader's writings no less than 7 times in that 1973 decision. He was later fully discredited, but he was an energetic and famous abortion advocate. Now, what business did the 1972 court have relying upon his statements, even if they were true, but they were lies? For example, he made the audacious claim that abortion was never a crime in the United States. Now, come on, that's pretty easy to look up. I mean, that one's just too bold. It was still illegal in 46 states as late as the 50s. The court simply ignored the overwhelming true history of state laws. I've got 3 podcasts on the history of abortion if you're interested, but suffice it to say, all the U.S. prohibited, the entire United States prohibited abortion in 1910. But rather than consult the Constitution or be honest about history, the court, believe this or not, the court, in addition to consulting Larry Lader, they consulted the AMA, the American Public Health Association, and they referenced the vote of the American Bar Association in 1972. This was an egregious abdication of jurisprudence. Legislatures can assemble policy based on opinions that are outside the Constitution, but the Supreme Court of the United States, they're supposed to be the measured adult in the room, and they're supposed to rule on the Constitution. The Supreme Court is supposed to be the anchor of constitutional freedom, regardless of the consequences. The 1973 court really went over the top. I mean, they drew lines that are reserved for legislative bodies. They arbitrarily defined viability. They said a state can intervene after the fetus is viable, but not before. What constitutional foundation did they have for that argument? And what about when viability changed? Because it did. At the time, it was 28 weeks back in 1973, but it's down to as little as 21 weeks today. The improved medical capabilities and technology have increased the odds of a very premature baby surviving. Yet the Roe decision built a framework of trimesters that were fixed, even though the definition of viability is medically changing. Alito asks the question, when is the fetus viable? At 10% survival rate? 25%? 50% survival rate? The 1973 court did not rule based on the framework of constitutional freedoms. They contorted themselves through an impossibly tortured logic. And many pro-abortion legal scholars admit there were problems with Roe. When abortion rights advocates try to defend the breakdown in logic, they scramble for a redefinition. They stretch out viability to what it means to be a person. They say a person is someone who has self-awareness or the ability to reason. So viability isn't physical anymore, it's mental acuity. Goodness, does that mean you can kill a child with learning issues since it might take a few years to determine if they have the ability to reason? And what kind of reason? And at what point does the state get to intervene and protect life? Casey, the 1992 reaffirmation of the right to an abortion, quietly dropped the weakest points of Roe, but replaced it with an arbitrary, undue burden test and relied upon a precedent test that was even weaker. The precedent test was itself. The undue burden test is about as opaque as you can get from a legal perspective. What in the heck is an undue burden on the mother? This 1992 court ruled that all abortions are okay as long as the mom can show that there would be some undue burden on her. You got to be kidding me. I mean, that's not a serious argument. The whole idea of being a mom is a burden. During pregnancy, after birth, raising the child, the whole package. It's a joy and a blessing too, but there's nothing easy about being a mom. Anyone can craft an argument for a burden. And it's a very simple extension of logic to create a definition of undue burden. Though this undue burden concept is not found anywhere in the Constitution, nor the notion of it, the 1992 court told the nation to just accept the ruling. No, literally they did. Casey declared a winner. The losing side no longer could seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the process. So in Roe, the court was wrong and stood on weak ground. Casey perpetuated the errors, wielding nothing but raw judicial power. The court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. So says Alito. Casey went beyond the court's role when it decided to reaffirm Roe and invent an undue burden test. Casey called on the contending sides to end their national division. We ruled, shut up. It claimed that the court had the right to impose a permanent settlement. This was an unprecedented claim, says Alito. It exceeded the power of the court. The court's supposed to exercise judgment to determine what the law means and how it should apply. Casey said that their ruling would end all debate. They sort of commanded the nation to be quiet and not talk about abortion anymore. Abortion on demand would be the law of the land. And you can sort out any details with the unburden argument. Neither Roe nor Casey ended any debate over the constitutional issue of the right to obtain an abortion. Not even close. The debate has continued to rage. In fact, in 2022, there were 26 states that joined Mississippi in asking the court to overrule Roe and Casey and return the issue to the states. The court did not end debate with Roe or Casey. Alito says that the court cannot bring an end to a rancorous national controversy by simply dictating a settlement and telling people to move on. Casey claimed that the national division on the issue would be ended with their ruling. All you pro-life people, shut up, and the issue is over. Well, that did not happen. The dissent, the liberal justices, tried to make a new argument for precedent that permanently shielded abortion from further review. It was a really novel concept. It said that since Roe caused controversy, it should not be reversed. No other case has used itself as the only foundation for precedent. I mean, you talk about circular logic. Do this because I say so. It has precedent since I already just said so. Alito's argument is simply, look, we've got a long-standing stare decisis capability of defining things. We got factors to figure out whether it's precedent or not. The 1992 Casey decision just uses itself for precedent. They have the audacity to believe that there is a special version of precedent for abortion cases only. So Alito reaffirms 5 times that the case is only about abortion. The dissent's worried that the same line of reasoning could be used with gay marriage and contraceptives, and Justice Thomas alluded to that, yet Alito goes out of his way to clarify that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Quote, abortion's different than marriage, since it uniquely terminates a potential life. Roe didn't end division. Casey has done nothing to end division since 1992. They halted a political process and deferred a stable settlement. So the majority ruled that it's better to kick the issue back to the states and let them do their job. So that's the Alito case against the dissenters. He also had some strong words for the Chief Justice. Roberts, in his concurring opinion, attempted to stake out a middle ground for the court, arguing that it didn't need to end Roe in its entirety and instead could have upheld Mississippi's 15-week limit on abortion. Well, Alito disagrees. He makes the cogent argument that all Roberts was trying to do was kick the can down the road. They'd be delaying some controversy today, but ensuring it would raise its ugly head in the future. And in the end, they wouldn't really get away from the controversy or the bad constitutional legal work. What about that? Roberts thought a more moderate solution would keep the peace a bit more. But it wouldn't resolve anything. It would just leave the issue to future cases. Alito said, there are serious problems with this approach, and it's revealing that nothing like it was recommended by either party. In fact, both parties asked the court to decide one way or the other. No middle ground. Both parties asked for clarity. Number one, either reaffirm it, or number 2, overrule Roe and Casey. So Alito thinks that Roberts' attempt to find a middle way would only prolong the turmoil of Roe. So Alito argues that making a narrow ruling doesn't really help. It just gives Mississippi what they want right now. But the high court would soon be called upon again to decide the constitutionality of other states' laws with shorter or longer deadlines for obtaining an abortion. So Roberts' quest for a middle way would only put off the day when we would be forced to confront and face that question head on again. The question, according to Alito, that we now decide. So Alito writes, the turmoil wrought by Roe and Casey would be prolonged. It's far better for this court and the country to face up to the real issue without further delay. Alito also thought the notion of giving people seeking an abortion a reasonable opportunity to obtain one was not a constitutional ground for upholding the flawed Roe versus Wade ruling and Casey. Alito said that if the Constitution protects a woman's right to obtain an abortion, the opinion does not explain why that right should end after the point at which all reasonable women will have decided whether to seek an abortion. Roberts has some tortured logic, and that's why Alito said what he just said. So Roberts was hoping for a middle ground, and it just wasn't possible here. Judges should be impartial and rule according to the Constitution. Roberts made no claim that the right to an abortion is constitutional. He simply wanted a middle-of-the-road approach. Roberts was not for abortion. He couldn't join the three liberal justices, yet Chief Justice Roberts has been trying to find middle ground ever since he invented a definition out of thin air when he ruled on the Affordable Care Act. He used to control the court, and he was able to do things like that. But with 5 justices who believe they are to be originalists, who don't really need Roberts to make a ruling, Roberts has lost his sway. He's in the middle, all alone. He seems to have no fundamental belief in freedom rights. He's neither an originalist nor a living document guy. Liberals believe the Constitution's a living document, that it can be interpreted through the lens of modern-day thinkers and adjusted and tweaked. Conservatives believe the Constitution is timeless, that there are some fundamental freedom principles that have to be preserved, and that it should be interpreted through an originalist's worldview. The crux of Alito's arguments from an originalist's worldview. In this instance, the 14th Amendment provides protections for certain freedoms. It does not explicitly mention abortion. Therefore, the federal government should limit itself to those rights that were understood to exist deep in the country's history at the time. And for the 14th Amendment, that would mean that originalists would look at the time around 1868 when it was ratified and then determine what the rights were understood to exist at that time. And then he shows that no one back then thought abortion was a right. In fact, there were numerous laws prohibiting it until Roe. As for Chief Justice Roberts, he finds himself with no one to rule. He tried for 7 months to get the 5 originalists to change their mind. None would do so. Roberts is alone in his wishy-washy place. He's somewhere between the living document ideology of the liberals and the originalism of the conservatives. You know, the West has been arguing about the morality of abortion for over 2,500 years. Most Western democracies have found some compromise between the far-left position that abortions on demand should always be available and the most conservative position that any abortion is murder. In Australia, Britain, Canada, France, Germany, and Japan, the legislatures have allowed abortion early in pregnancy and made it illegal later. But notice, in those countries, the legislature solved the problem. The legislature works closest to the people. The U.S. solved the problem in 1973 by fiat from the Supreme Court. They did it again in 1992. That didn't solve anything. So, the Supreme Court of the United States asserted proper jurisprudence here. They overturned an unconstitutional ruling. They properly overturned Roe and Casey. The issue is now kicked back to the state's legislative body. They'll have to sort it out. This issue is not going away. Some states will prohibit abortions at some level. Others will allow abortions on demand. There'll be a lot of political thought up on both sides about it. Now, I'm personally for life. And I believe that if government should do anything, it should protect innocent life. You may disagree, but at least now we can debate the issue in its proper forum. To your freedom.
Hi, I'm David Farah. Thank you for listening to my dad's podcast, The Barry Farah Show, Culture Shift. Click subscribe now to be sure you don't miss an episode. Share this podcast with your friends on social media and give The Barry Farah Show your 5-star rating. See you next time.